Eyewitness News legal analyst Chick Foray has been following today's proceedings from an overflow courtroom set up for reporters.
And he joins us now live outside of criminal court with his take on the work to choose a jury. What struck you about today's proceedings, Chick?
Well, it's been a long day, but I tell you what, I think it's been a productive day, Karen, Natalie. The jury has moved forward with the selection process. I think the questionnaires that were sent out by Judge Burris have played an important role in streamlining the jury process. There were 11 jurors selected. It seems like we're going to need a pool of 40. They're now selecting more jurors. I think we'll have a jury sometime around 9, 10 o'clock this evening.
In this case, there was some thought that perhaps the jury selection might be difficult or take a while. Is it moving more quickly than you thought it would?
Yeah, I think so. I think it's moving more quickly, but this is a tough process. Many questions about sequestration. When the judge asked about sequestration, a lot of the jurors said that they had dental surgery, prior commitments, other commitments that they had to attend to, and it would be impossible for them to be sequestered. That is sequestered, meaning locked up or contained together for a week or so. So that's a tough situation when you have a sequestration of a jury, where you're locked up for 7, 8, 9 days. They also ask questions about the publicity. Remember, this case has been so well publicized. A lot of the jurors said, yeah, we've heard about the case, but the judge asked further questions that said, even though you've heard about the case, and even though you may have thought that you reached a decision about this, can you still have an open mind? Will you listen to the witnesses on the witness chair? Will you listen for the presentation of the evidence? And almost all of the jurors said yes. There's a number of ways you can strike jurors. You can strike jurors for cause, challenges for cause. That's up to the judge. And that would be someone who says, no, Judge, I can't be fair. I've already made my mind up. There are peremptory challenges, 12 on each side, where each side gets to cut a jury for no reason, supposing they just don't like the questions, the answers to the questions that were asked of those jurors. Each side has 12 of that. There'll be 12 jurors, 4 alternates. I think we'll get a jury tonight, and I'm very confident we'll have opening statements tomorrow, and perhaps even the presentation of some evidence.
And Chick, I know some of the questions centered around reasonable doubt. And did you, what does that mean legally, and do you think it's often misconstrued?
What I always argue to jurors is reasonable doubt is you use your common sense, and it's a standard that you use in the most important decisions of your life. Do I get married to this woman or this man? That's a reasonable doubt. Is this the person I want to marry? The standard that you use in the most serious decisions. Is this the house that I want to buy? Common sense application for the most serious decisions that you make in your life. It's not, oh, I think he probably did it, so I'll find him guilty. No, it's whether or not you can give a good reason for that doubt. The standard is the most serious standard that you use in your decision-making process for your major life decisions, and you use your common sense, and you look at the evidence and you look at the law.